Well, there's certainly quite a big overlap between proprietary estoppel and trusts. I mean, I think the best way of approaching it is to see proprietary estoppel as a means of acquiring rights. It's a type of claim that someone can bring in certain situations to acquire a right, whereas trusts are a particular type of right. So the type of right that you get as the beneficiary of a trust, that one of the ways that you could acquire such a right is through a proprietary estoppel claim. So equally, there might be lots of proprietary estoppel claims that don't give rise to a trust. They give rise to a different type of right, perhaps even just a personal claim for money. And conversely, there are lots of trusts that arise through reasons unconnected with proprietary estoppel, as when I just orally declare a trust, for example. So I think that distinction between ways of acquiring rights and types of right is quite important. And in one of the chapters in the book, I look at the impact of formality requirements on proprietary estoppel. And one of the interesting things there is that because of a worry about a particular piece of legislation, judges have tried to say that lots of proprietary estoppel cases also give rise to constructive trusts. And I think actually in lots of those cases, it's not accurate to say there's a trust, because when you look at the type of right that the claimant's got, it's not a right which involves a trust situation. It doesn't involve a trustee holding a right for the benefit of a beneficiary, for example. So in those cases, it'd be much better to say, well, that there isn't a trust here, but the claim can still succeed on the basis of proprietary estoppel, and the reason you don't need to comply with the formality requirement in this piece of legislation, which is Section 2 of the Law of Property Miscellaneous Provisions Act 1989, is because that legislation only applies to contractual claims, and there's a very important difference between contractual claims and proprietary estoppel claims. So I think the crucial point there is the distinction between ways of getting rights on the one hand and types of rights on the other.